Welcome back to Radio Entrepreneurs. I'm Mark Z, and I have my unbelievable co-host Mark Furman with me from Tarlow, Breed, Hart Rodgers. And Tarlow, Breed, Hart Rodgers has been very terrific as a host, in addition to Mark giving his time to be my co-host today. Mark, thanks for coming.
Mark, great to be with you, and I'm very excited to hear from an old friend, Ken DeMoura.
Absolutely. Ken DeMoura is at DeMoura Smith, and he's a partner, founding partner. And Ken, thanks for coming back on the show. We're excited to have our listeners hear you on some very topical subjects.
Well, thanks very much for having me, Mark. And Mark, good to see you again.
Nice to see you. And one of the things that we had talked about, because you're dealing a lot in the employment litigation area and labor, is the statute that's been coming to fold in a lot of people's eyes. Companies don't want to see it, and potential employees do want to see it, and there's a lot of back and forth on the non-compete statute that the state is evaluating right now. I believe it's been proposed as a bill in the state sessions, the state legislature sessions. Is that correct?
That's right, Mark. We have, this is probably the third or fourth time around where legislation has been proposed to limit non-compete agreements in Massachusetts. And I think this summer was about as close as the legislature had ever come to passing a statute. The House passed a version, the Senate passed a version, but it ended up that there were significant differences between the two bills. There were probably 4 areas of disagreement. And everybody, I think, thought that the issue was going to be dead until the new legislature came into session next year. But the White House had a summit in October on non-compete agreements and how that's affecting the competitiveness of the United States. And the Senate leader of the Massachusetts Senate went, and so did the House representative that's actually leading the conference committee on the bill. They were both at that White House session, and they ended up sort of sparking or reigniting the discussion about the Mass bill. And there is talk, and there is some possibility that they might actually pass a bill within the next couple of days before the end of this legislative session, if they can iron out the last 2 or 3 different differences between the House version and the Senate.
Interesting. Now, tell the audience what the differences are.
Sure. The differences have to do with, first of all, the duration of a non-compete. The House version had that a non-compete could not last for longer than a year. The Senate bill wanted it to be a 3-month duration. The second was what's called garden leave, which is that both the House and the Senate said that if an employer wanted to enforce a non-compete, they had to pay that employee during the period of non-compete after they leave the company. And in the House version, there were the parties could reach an agreement on what that payment would be, and it was probably, if you look at it, probably going to be less than full salary. Whereas the Senate version said that if you want to enforce a non-compete against an employee, you have to pay them 100% of the average salary of the last 2 years or 3 years that they were employed there. So that part of the bill has some significant differences. The Senate bill also had a provision which said that if there were any part of the agreement that was unlawful, then the whole agreement had to be thrown out, versus the House version, which said that a judge would be able to, what they call blue pencil an agreement, and permit the judge to modify or allow those portions of the agreement that were lawful to stand. And then finally, the type of employees that would be subject to non-compete agreements. The House bill had that non-exempt employees could not be subject to the bill. Interns or students could not have to sign non-compete.
So by non-exempt employees?
Right, non-exempt employees were...
Just tell our audience.
Yeah, a non-exempt employee is an hourly employee, for example, would not be an employee who would be required to sign a non-compete. You couldn't enforce one against them. And then the other important point about the House bill was that if you were laid off or you were terminated without cause, the employer would not be able to enforce the non-compete. The Senate bill had all of the same provisions, but it also said that anybody who made less than $130,000 a year
Right.
would not be subject to a non-compete. So that was, if you think about, the workers in Massachusetts, that takes a lot of workers, a lot of employees in Massachusetts who would not be covered by the bill. So I don't know where it all stands right now. I understand from people I talked to at the State House that they're probably have narrowed it down, maybe where there's one or two of these 4 issues that are still in play or still being discussed to see if they can reach a compromise. But I do think that the conference committee does want to try to present to the full legislature a bill that they can get to the governor before the end of the year.
So we're not quite likely to go as far as California, which doesn't enforce non-competes at all, but we're going to greatly limit them if this bill passes.
I think you're right, Mark. I think, and I think that's going to happen with the mixed reaction in the business community. There are lots of entrepreneurs who think that that having non-competes is actually stifling their ability to recruit and attract talented people. And then there are others who say, well, once I have somebody, I want to be able to protect my ideas, and I want to be able to protect my company if they decide to leave and go to a competitor. So there's that tension. I know there are a lot of the larger companies, of course, want to maintain the state of affairs as it is now. But yeah.
So I was reading actually this morning about a settlement franchise, sandwich shop franchise. See if I can remember the name, Jimmy John's.
Yes.
Oh, yeah,
They just settled with a regulator agreeing not to have any non-competes because they were getting them routinely, it sounded like, from the folks who were making the sandwiches and subs. So, what's and it was, I forget from the article whether they couldn't work for a sandwich shop that did more than a restaurant that did more than X% of sandwiches or subs. And it seemed like it was just too much, and this was, I think, the second state that they had been sued about that. What I see a fair amount in my practice are companies who either decide to have a non-compete or don't, but I like to emphasize to employers, it's kind of a three-headed issue. We're only talking about non-competes, and that's where the controversy is, but companies can write agreements that prohibit employees from soliciting other employees of your company. Those are enforced routinely by the court.
Sure. Yeah.
And then confidentiality agreements to protect your trade secrets also are routinely enforced, if they're really secrets.
Right.
But non-competes where all the controversy is. So, the issue is, do you really need a non-compete? In our, the law of non-compete evolved when people went to work for a company and routinely stayed there for decades.
Right, yeah.
Probably had a pension there. Them days are gone, as they say, and people's expectation of how many companies that they're going to work for over the course of their career is just completely different.
Oh, career mobility now
Yeah.
is so different than it used to be, and I do think that the judges understand that and appreciate that. So sometimes I think when you have a case that you're litigating on a non-compete, they're looking for ways to let that employee go work for the other company, and if they can carve out various exceptions or find that there wasn't consideration given for the non-compete, or that the conditions of employment changed, they'll try to do that. But I think that, I think the time has come for the legislature to step in and, you know, set some rules, guidelines.
Clarify the rules of the
Sure.
road for
Yeah.
everybody.
I think from a clarification, as you would say, Mark and Ken, I think it's a good thing. Giving you another perspective, when you talk about big companies, from a small company like mine that has non-competes, you train somebody and you put your heart and soul to somebody who never knew the business, and then that person, you know, sure, there's only so much you can do about confidentiality, there's only so much you can do in terms of the way something works, but then you have somebody that can go out directly and compete with you after you've invested that time.
Sure.
So I think it's very good to have some clarification. We've always done very reasonable in time and distance, much less than what's required here, because if people want to move on, we don't want people to have their livelihood hurt. On the other hand, we need to protect our investment, because again, they're going to come right back to us and compete against us, so.
Well, and that's precisely the concerns that the companies who have been opposed to that have been articulating to the legislature, and I think those are justified concerns. You know, you get a company that, like you say, invests a lot of money in training staff or bringing people in at an entry level who then, you know, become very, very good at what they do because of the resources that the company has put into them.
Right.
It is a legitimate concern, and I do think, unlike California, where they've just outlawed it, and in 2 other states it's outlawed too, Oklahoma and North Dakota, I think. I think there is a recognition that there has to be a balance.
Right, otherwise there's gonna be a chilling effect on one hand, you have entrepreneurs that wanna hire and get talent. On the other hand, these same entrepreneurs are gonna find that if they bring on that talent, it could come back to haunt them too.
Sure.
On that note.
So don't hire an entrepreneur.
There you go, there you go. On that note, Ken, it's been great to have you on the show again. If one of our listeners wants to reach you on this topic that's very apropos for so many businesses, how would they do that?
Well, they can reach us at DeMoura Smith, which is a Boston law firm, and my email is kdemoura@DeMoura Smith, or they can call our office, 617-535-7531.
Excellent. I'm Mark Z, and I've had the pleasure to have Mark Furman as my co-host at Tarlow Breed, Hart Rodgers, our host and my co-host. Mark, great to have you here today.
Same here, Mark.
Thanks again, good to see you.
Thank you,
Nice to see you.
Ken.
Thank you,
Great
Ken. And we're radio entrepreneurs, and we will be right back.